Hello everyone, my name is Satyam Shivaach and I am working as a legal intern with LEXIS and Company, and in this video we will discuss about separation of power. In India, separation of function rather than power is followed. Unlike in the USA, in India is a concept of separation of power and is not adhered to strictly. However, a system of check and balance have been put into a place in such a manner that the judiciary has the power to strike down any unconstitutional law which has been passed by the legislature. Today, most of the constitutional system do not have a strict separation of power between the various organs in a classical sense because it is impractical. In the following section, we will discuss about prevailing system in India and what are the relationship between each organ. Let's start with what is legislature. The chief function of the legislature is to enact law. It is the basis for the functioning of the other two organs, the executive and the judiciary. It also sometimes accorded the first place among the three organs because unless a law has been enacted, there cannot be no implementation and application of law. Now, what is the executive? The executive is the organ that implements the law enacted by the legislature and enforces the will of the state. It is the administrative head of the government, and the minister, including prime minister, chief minister, president, and governors, forms part of the executive. Now, let's see what is judiciary. The judiciary is the branch of the government that interprets the law, settles dispute, and administers justice to all the citizens. The judiciary is considered as a watchdog of democracy and also a guardian of constitution. It comprises of the Supreme Court, High Court, District Court, and other subordinate courts. Now let's see what is separation of power. In the strict sense, the doctrine of separation of power is very rigid. The concept was first seen in the work of Aristotle in the 4th century, where he described the three agencies of the government as General Assembly, public officials, and judiciary. In the ancient Roman Republic too, there was a similar concept which was followed. In modern times, in the 18th century, French philosopher Montesquieu, who made the doctrine a highly systematic and scientific one, in his book The Spirit of Law. His work is based on an understanding of an English system which was showing a propensity towards a greater distinction between the three organs of the government, and the idea was developed further by John Locke. Now let's see the purpose of separation. The purpose of separation of power is to prevent abuse of power by a single person or a group of individuals. It will guard the society against the arbitrary, irrational, and tyrannical power of the state, and safeguards freedom from all and advocates each function to a suitable organs of the state for effective discharge in their respective duties. Now let's see the meaning of separation of powers. Separation of power divides the mechanism of governance into three branches, that is legislature, executive, and judiciary. Although different authors have given different definition, in general we have came across the frame of three features of the doctrine. First being each organ should have different person in capacity, that is a person with a function in organ should not be part of another organ. Second is the one organ should not interfere in the functioning of the another organ, and the third is the organ should not exercise the function of another organ. Thus, these broad spheres are determined, but in a complex country like India, there often arises conflict of transgression by one branch over the another. Now let's see the significance of this doctrine. Why do we need a separation of power between various organs of the state? Whenever there is a contraception of power in one central authority, there is bound to be a greater chances of maladministration, corruption, nepotism, and abuse of power. The principle ensures that the atrocity does not creep into a democratic system, and it protects citizens from arbitrary rules. Hence, the importance of the separation of power doctrine can be summed up as follows. First, it keeps away autocracy. Second, it safeguards individual liberty. Third, it provides help which creates an effective administration. Fourth, the judiciary's independence is maintained. Fifth is it prevents the legislature from enacting arbitrary and unconstitutional law. Now let's see constitutional statutes of separation of power. The doctrine of separation of power is a part of basic structure of constitution, although not specifically mentioned anywhere. The legislature cannot pass a law violating this principle. The function of the three organs are specifically mentioned in the Constitution. Let us take a look at the sum of the articles in the Constitution. First is Article 50. This article puts an obligation over the state to separate the judiciary from the executive, but since the fall under the directive principle of state policy, it is not enforceable. Next is Article 123. The President, being the executive head of the country, is empowered to exercise legislative powers, which is promulgate ordinance in certain conditions. Now the next is Article 121 and 211. These provide that the legislator cannot discuss the conduct of a judge of a Supreme Court or High Court. They can do so only in the case of impeachment. Then the next is Article 361, where the President and governors enjoy immunity from court proceedings. This is the system of check and balance wherein various organs impose a check on one another by certain provisions. The judiciary have a power of judicial review over the action of the executive and legislature. The judiciary also has the power to strike down any law which has been passed by the legislature if it has been held unconstitutional or arbitrary as per Article 13. It can also declare unconstitutional executive action as void, and the legislature also reviews the functioning of the executive. Although the judiciary is independent, the judges are appointed by the executives. The legislature can also alter the basics of the judgment while adhering to the constitutional limitation. Checks and balance ensure that no organ becomes all too powerful, and the Constitution guarantees that the discretionary power bestowed on any of the organ is within the democratic principle. Now let's see some of the judicial pronouncement upholding the separation of doctrine. Starting with the Keshavananda Bharati case in 1973. In this case, Supreme Court held that the amending power of the Parliament is subject to the basic feature of the Constitution, so as any amendment violating the basic structure of the will be declared unconstitutional. Then in the case of Swaran Singh case in 1998, in this case Supreme Court held that the UP's governor's pardons of a conflict unconstitutional. Checks and balance. The strict separation of power that was envisaged by the classical sense is not practical anymore, but the logic behind the doctrine is still valid. The logic behind the doctrine is of polarity rather than strict classification, meaning thereby that the center of authority must be dispensed to avoid absolutism. Hence the doctrine can do better appreciate as a doctrine of check and balance. Now let's see judicial overreach. The Supreme Court has been accused time and again of pronouncing judgments that are often termed as judicial legislation. This happens when, in the guise of giving guidelines and creating principles, they assume the power of the legislature. For instance, by laying down some of the basic structure doctrine, the Supreme Court has put limitation on the legislative power to make and amend law. The judicial, through the collegium system, has also been accused of infringing the power of other branches. The essential function of the judiciary is to interpret the law, rather than to keep the appointment of judges. After all, our parliamentary form of democracy, wherein the parliamentaries are elected by people and they have to face the people. They are filing the slogan "We the people." As compared to this, judges are enjoying fixed tenures. They are accountable to none as such, and they should concentrate on justice delivery rather than the appointments. That is all for today's video. Thank you for watching. Please like, share and subscribe.